It didn't feel like a normal morning in America. It didn't feel like another day of ordinary politics or routine legal news. It felt like a blast wave, a constitutional shock ripping straight through Washington the moment the Supreme Court dropped its newest ruling. No leaks, no warning, no gradual buildup. Just a sudden, thunderous decision that hit the nation with a level of force that legal experts instantly described as historic, explosive, and the most aggressive expansion of Second Amendment protections in decades. Overnight, with one 6-3 ruling, the Supreme Court didn't just interpret the law, it transformed the entire national understanding of gun rights. And every gun owner in America must now prepare for 9 massive changes that will shape the future of firearms across all 50 states. The ruling came from a case many people assumed would be minor, procedural, or narrowly focused. But the court had other plans. From the opening pages of the majority opinion, it became clear this ruling was not just another step in the Bruin era. It was a full stride toward reshaping the boundaries of federal and state power over firearms. The court declared with absolute clarity that the Second Amendment must be interpreted as a real enforceable constitutional limit on government, not a flexible suggestion that politicians can bypass whenever it's politically convenient. And with that statement, the court launched a seismic shift that immediately began rewriting laws, restricting agencies, limiting states, strengthening individuals, and forcing the entire American legal system to realign itself. The first and most shocking element of the ruling was the court's announcement that gun regulations must meet a dramatically tightened historical standard. The majority said that too many lower courts were twisting the Bruin test, trying to water it down, reinterpret it, or create excuses for applying modern public safety concerns instead of historical analogies. The Supreme Court slammed that door shut. The justices wrote that if a gun law cannot be directly tied to the founding era, not 1900, not the 1930s, not the 1960s, then the law stands on unconstitutional ground. This single change immediately puts pressure on dozens of regulations that rely on 20th century interpretations, including magazine limits, carry restrictions, assault weapon-style bans, registration requirements, and countless agency-created rules. But the ruling didn't stop there. The court went deeper, turning its attention to federal agencies, especially the ATF, and delivering a devastating blow to their power. The majority declared that federal agencies cannot create new criminal categories or expand the definition of firearms through administrative decisions. That language directly attacks years of ATF actions involving pistol braces, frames and receivers, SB classifications, stabilizing accessories, suppressor components, DIY kits, serialization rules, and much more. The court wrote that agencies are not permitted to reinterpret Congress's silence as authority, effectively gutting the legal basis for entire categories of ATF rulemaking. Gun owners across America suddenly realized that many of the rules they had been forced to comply with, rules requiring registration, rules demanding paperwork, rules criminalizing technical configurations, may now be on the chopping block. As federal power shrank, the ruling also delivered a massive blow to states. The court struck down the idea that states can impose new public interest gun restrictions unless those restrictions clearly existed in the founding era. That means states like New York, California, New Jersey, Illinois, Maryland, Hawaii, and Massachusetts. States that have been aggressively passing modern gun laws now face a tidal wave of constitutional challenges they are unlikely to survive. The ruling specifically criticized states for creating layered licensing systems that delay or deny gun ownership through excessive fees, long waiting periods, or bureaucratic obstacles. The court said, these systems violate the Second Amendment because they function as administrative barriers, not constitutional protections. This statement alone places massive pressure on everything from FOID cards to handgun permits to ammunition licenses. One of the most dramatic impacts of the ruling is its effect on so-called sensitive places laws. The law states have been using to ban concealed carry almost everywhere except inside your own home. The court condemned these bans as geographically excessive, saying that Americans cannot be stripped of constitutional rights simply because a state declares half the map off limits. The ruling emphasized that the Second Amendment protects the right to carry for self-defense in public, not just at home, and the court warned that states trying to undermine this principle will face future intervention. Overnight, thousands of signs reading gun-free zone became constitutionally questionable, and politicians who supported these bans suddenly found themselves cornered, criticized, and scrambling for backup. The ruling also destroyed the idea that gun rights can be restricted based on subjective standards like good moral character or government discretion. The court wrote that rights cannot depend on the personal judgment of bureaucrats. They cannot depend on whether an official likes you, trusts you, or believes you are worthy. Rights cannot be earned through approval. They exist by default. This is a monumental change because many states rely on subjective permitting systems that give local officials the power to deny applications for vague or arbitrary reasons. That era is now collapsing. And then came the ruling's most explosive element, the redefinition of who counts as a prohibited person. For years, federal law has prevented certain individuals from possessing firearms under categories that were sometimes overly broad or poorly defined. The court now insists that only individuals who pose an immediate provable threat to public safety can be stripped of their rights, not people who committed minor offenses decades ago, not people with old nonviolent charges, and not people banned under regulations that have no historical foundation. This declaration instantly opened the door for challenges to major federal laws involving nonviolent felonies, restraining orders, and even certain misdemeanor categories. Legal analysts immediately predicted that thousands of Americans may regain firearm rights as the new standard filters through the courts. The ruling also addressed firearm technology. The court declared that the Second Amendment protects weapons in common use, and the government cannot ban weapons simply because they are modern. The justices wrote that the founders expected technology to evolve and that new firearms, accessories, and designs remain protected as long as they serve lawful purposes. This language is a direct threat to assault weapon bans, suppressor restrictions, SB rules, and many state-level equipment bans. The court warned that politicians cannot criminalize weapons based on appearance, popularity in media, or emotional arguments. The Constitution, not fear, defines the law. Politically, the ruling detonated like a nuclear event. Republican states celebrated the decision as a historic restoration of constitutional rights, while blue states called it dangerous, radical, and a threat to public safety. The White House immediately criticized the ruling, with officials warning of major national consequences. Meanwhile, gun rights organizations FPC, GOA, NRA, Second Amendment Foundation erupted in celebration, calling the ruling a monumental victory. Within hours, legal teams across the country began filing lawsuits targeting dozens of federal and state laws, knowing the Supreme Court has now handed them one of the strongest Second Amendment precedents in American history. But perhaps the most important part of the ruling is the court's message about legislative responsibility. The justices wrote that the Constitution was designed to prevent unelected bureaucrats from controlling national policy on fundamental rights. The ruling said Congress must speak clearly if it wishes to regulate firearms. No more vague language, no more broad delegations of power, and no more laws that agencies can weaponize through reinterpretation. This statement reshapes the entire legal landscape and ensures that the future of gun rights will rest on constitutional clarity, not administrative improvisation. As America absorbs the shock, experts predict a massive wave of change. Entire categories of gun laws may fall. Federal agencies may lose key powers. States may be forced to rewrite codes from scratch. The Supreme Court has signaled that the Second Amendment is not flexible, negotiable, or symbolic. It is real, enforceable, and absolute. And that reality is now redefining every corner of American law. So where does the nation go from here? In the short term, lawsuits, many of them. Every major regulation from magazine limits to SBR rules to sensitive place restrictions is now vulnerable. In the long term, Congress will be under intense pressure to respond, but in the immediate moment, gun owners across the country face one vital responsibility. Understand the 9 major changes this ruling has unleashed. These changes will determine what you can own, where you can carry, how you can defend yourself, and what rights you pass on to future generations. The Supreme Court has spoken with thunderous clarity. The new era has begun. Gun rights have been transformed, and every American gun owner must now prepare for the most significant shift in Second Amendment